Legal disclaimer: please note this information is not to be considered legal or financial advice. It is for educational purposes only. Furthermore, it is not intended to lead you into any particular course of action. We recommend that each person do his or her own due diligence. We feel every American should know what law is. Any actions you may take as a direct result of your discoveries obtained from this presentation are and will be of your own free will. In addition, the information and reference material provided on this website does not constitute endorsement of the source. Links provided to second-party websites are intended for research purposes only for the users of the site. Referenced material is not intended to prove or disprove the processes or a strategy presented on this site, and does not provide validation of methods used. We have no affiliation and imply no connotations with reference sites sponsored, maintained, created, edited or updated by the Federal Trade Commission, Cornell University Law School, the Better Business Bureau, or the National Association of Attorney Generals. We do not advocate any unlawful actions. We simply promote the law, as written, and as found within information acquired. We cannot and do not give any legal or financial advice to any entity under any circumstances. We simply provide information, education, laws, codes, sources, cases, history, and other documentation to allow you, the reader, come to your own conclusions and pursue further research if you so desire. 6 things: warning signs that you be foreclosure upon illegally and why it makes sense to fight back. Warning sign number 1: you get served with summons and complaint, look through the papers and don't see an assignment off mortgage with the plaintiff's name on. In paragraph 3 or 4 it says something like to be assigned, or if the assignment is in the name of a mortgage servicer, for example Citi Mortgage. Reason: the law firm like Stephen J. Baum or some similar firm is rushing to get to the courthouse to file a foreclosure and doesn't have an assignment of mortgage to present to the court, or they start the foreclosure process and present a fraudulent assignment signed by someone to pretend like they have the right to foreclose. If you're being sued by Deutsche or any other trustee or even a mortgage servicer and they present an assignment of mortgage to court executed days before a foreclosure or after the foreclosure was filed, it was likely mostly created fraudulently by a third-party servicer like LPS, who hired a firm like Stephen J. Baum. The reason these assignments are fraudulent is because they usually are not made by anybody with any authority and sometimes signed by the law firm themselves, which is a big no-no. An assignment made by MERS, for example, would have to have been made years ago to become valid when your mortgage company was actually in business and assigned them to securitize trust. If it was made to servicer, it's done for administrative reason, but it still doesn't reveal who the real party of interest is. According to the Truth in Lending ACT.at best, any assignment of mortgage is a memorialization of something that should have occurred, but what should have occurred what did are two separate things and does not fly in court. How to use this to your advantage: you can do a check on OCREs if you live in New York City, or if your county recorder is online, to see if an assignment of mortgage was recorded when the foreclosure was filed. Google your county and the term recorder of deeds. If you live in Long Island, unfortunately you are going to have to go and get a cheap title search done. I know of a firm that will run a judgment search for about $150 with results to you in 2 days. Answer pros@gmail.com. When you answer the summons and complaint, say that the plaintiff did not have a valid assignment of mortgage when they began, and that any document presented as an assignment is authentic, and even allege it's a forgery, and that the original note needs to be presented to the court as proof of ownership. This tactic alone makes some foreclosure attorneys throw in the towel, but the more you need to build your defense. Warning sign number 2: they lie or purposely conceal from the court who actually owns the mortgage and note, so you can't rescind your mortgage, assert claims of predatory lending, or negotiate a modification terms with a creditor directly. Reason: the parties that really own your mortgage and note are never going to come to court and don't take the time to do so. They hire the servicers for that particular purpose. A lot of times they are actually suing the people who are suing you for other reasons and could care less about your house. It's your right under the Truth in Lending Act to know who actually is the owner of the loan note, and you should be able to assert a claim or negotiate with the actual net owner, not a middleman. Also, it's been my experience that you get better terms if you negotiate with the actual net owner, because he may well have bought it for 30% on the dollar, so can negotiate to save your house at 50% of on the dollar, and it actually makes them a profit. But if you have a middleman that is blocking the both of you from talking to each other, then this is where the problems start. In a securitized trust or any loan that is default, the mortgage and note are constantly sold between third parties for pennies on the dollar. Sometimes the same mortgage is sold to multiple parties within a trust. You have a right according to the Truth in Lending Act to know who the owner of the mortgage and note is at any given time in writing. When a loan is in default, it usually gets deleted from the trust, is charged off like a credit card, and sold to a third party who is not included in your foreclosure suit, who may be the actual owner. This is violation of law and is cause to get a foreclosure dismissed. The trick is that you have to prove this, but there is a way to get a big-name law firm to help you with this fact-finding. How to use this to your advantage. Here's something that most homeowners will never discover. Your actual mortgage company never communicates with the actual lawyers doing the foreclosure. Although they are calling the shots, they hire a third-party servicer called LPS to deal with the lawyers. But if you contact your mortgage company through correspondence and ask them who owns your note, the information they give you can be used in court against them, and they won't even know it. Let me explain. Mortgage servicers have different rules they have to abide by as a result of federal laws protecting consumers. One law that most lawyers and even judges don't know is that if you write to your mortgage company and ask them who owns your note, they have to tell you and give you a name, address and phone and person to contact. If they fail to do so in 30 days, you can sue the mortgage company for $4,000 plus attorney fees for failing to comply. The name of the law is called the Truth in Lending Act, but the section is called 15 US 1641 F2 and the 15 US 1641 G1. Now, most mortgage servicers will ignore you if you write them this letter, although by law they have told sir, but a lot of times they fail to do so. However, I have found a great way to get a quick response from your lender using a little-known service called prepaid legal. For $35 you can join their service and pay them write you this letter, and use the fact that you wrote the letter to include in your arguments with the judge as to who really owns the note. For information on using this tactic, continue reading the ebook until the end. Warning sign number 3: they fail present to the court. They were authorized by the debt holder to start a foreclosure on their behalf of the owner. Reason: the average pooling and servicing agreement is 150 to 200 pages long. If they can't get an assignment to the court, what makes you think that they will submit a pooling and servicing agreement as to what the terms and conditions are that give them authority to act on behalf of the trust? They don't even record a power of attorney with the assignment to show how they are eligible to act on behalf of the owner of your promissory note. Basically, they are acting rogue, filing foreclosures in hopes homeowners won't defend the foreclosure. How to use this to your advantage: the pooling and servicing agreement can be used to catch the so-called plaintiff in a lie as to when the assignment of mortgage actually occurred and how much was paid for the mortgage. A tactic that most homeowners rarely used, but if they did would really strengthen their case against the lender, is discovery. In discovery, you can ask the opposing party questions that relate to the facts of the case that could invalidate their claim. You can also use a discovery to ask the lender to produce the original note and the payment ledgers attached to that note, proving that they bought it. If you feel the closing wasn't done up to par, you can ask the plaintiff to produce certain documents needed that were not included in the process to show your rights are violated, as well as stuff related to who the owner is according to the Truth in Lending Act mentioned above. Warning sign number 4: they present fraudulent evidence from witnesses who have no personal knowledge about how much you owe, and sometimes from people who don't even work for the mortgage company. Reason: most affidavits submitted by attorneys for the bank never contain any business records or actually proof you're in default. Remember, as mentioned above, your mortgage could have been paid off as a result of the insurance placed against you for being in default. If the note was paid off, how can you owe a debt? The statements that you owe can only be categorized as hearsay. It is the business records that determine such a proof.
If not the statements of an unknown party. Furthermore, as mentioned above, a securitized trust can't buy a loan.
We can stop foreclosures in their tracks.
I am freedom. All my thoughts
must answer your summons and complaint. Contact us and we can get you help to answer. If not, you lose by default. You can fight foreclosures and win pro se. Let us help walk you through. Don't wait because you can lose your home. Call 518-768-1593 or email answers@gmail.com. We can help.
There is no thing called sin. Freedom is singing like a bird